Good afternoon, counsel. Can you see and hear me?
Yes, Judge, I can.
All right, looks like Mr. Hashimi is connecting to audio. Can't hear him just yet.
Good afternoon. Can everyone hear me?
Yes, I can hear you now, Mr. Hashimi.
Thank you very much.
Okay, all right. This is cause number 19-226, Huff V Wilson. And I believe what's before the court today is the defendant's motion to quash deposition by written questions. Is that correct, counsel?
That is correct.
Okay, and Mr. Cook, I have read your motion, and I have also read the reply. So I guess what we'll do is I'll just go ahead and let you restate your motion, understanding that I have reviewed it, but want you to go ahead and argue what you think are the most compelling points.
Yes, Judge. Essentially, I represent the defendant. The plaintiff has filed some affidavits to prove up the cost and necessity of some medical care. And I filed a controverting affidavit signed by Jana Schieber. Jana Schieber is generally considered in Texas to be a consulting expert witness. However, to the extent that her opinions have been disclosed through her controverting affidavit, any privilege has also been waived as to those matters. However, plaintiff's counsel has sent a deposition by written questions to Ms. Schieber's employer to get some information about Ms. Schieber's opinions and the basis thereof. However, Rule 195 of the Texas Rules of Civil Procedure says that the only allowed methods of expert discovery are through Rule 194 disclosures and through Rule 195, which allows for oral depositions, not depositions by written questions. I think it is generally inappropriate for them to go over the head of the expert to the expert's employer generally, but in particular, it is inappropriate to use a deposition by written questions to do this. And so I think that the court should quash the deposition by written questions because it's not allowed in expert discovery.
Thank you, Mr. Cook. Mr. Hashimi, would you like to respond?
Thank you very much, Your Honor. Your Honor, you stated that you have read the motions. I just want to state very quickly the factual basis here, Judge. We filed the affidavits of the providers, and in opposition to our affidavits, my opposing counsel filed a controverting affidavit as only to the reasonable charges, not the necessity of the services, but reasonable charges of the providers. Okay, so the case law, and that is by Ms. Jana Schieber. I have actually deposed Ms. Jana Schieber in other cases. Ms. Jana Schieber is an employee of a litigation support service called ExamWorks. ExamWorks provide her with the data. Data is not opinions or mental impressions. They're actually facts. It's data. She then reviews the data, creates a chart, which she has included the chart, but not the actual data, which needs to be included. And she opines regarding that data that she used. That is not included in her affidavit. The data is not in her possession. She doesn't have control of it because it comes through a subscription service through her employer. What my opposing counsel didn't tell you is that I have sent requests for productions. I haven't received anything. I've sent disclosures. I haven't received anything. Now, the controverting affidavit, Judge, it needs to be done by a person who's qualified. Now, I've deposed Ms. Jana Schieber. She has an extensive CV. At least I am not going to claim that she's not qualified. I don't know a basis for her not to be qualified, okay? The second prong of an affidavit, the information has to be reliable, okay? in order for me to figure out if the information is reliable, I actually need the information. Judge, may I have permission to share my screen with you to just show you what she is depriving us and what it is I'm trying to get. And then I'll get to the arguments as to the 195 and the 194.
Yes, sir. Go ahead.
Thank you, Your Honor. Your Honor, at least I'm attempting to share my screen over here. I have highlighted some portions. I'm scrolling up and down. I just want to make sure and verify that you're able to see this.
I am.
Thank you, Your Honor. Let me zoom in for a second, if I possibly can. Let's see. There we go. Your Honor, this is the controverted affidavit of Ms. Janice Schieber. She controverted the chiropractor that and the therapy people that worked on my client, treated my client in Canton, Texas. I think the pain and orthopedic doctors have also been controverted. Okay. Now, what she does, Judge, is so this is her affidavit, and it follows with her CV, which I don't have any issue with, which she has produced, followed by a bill review summary. Okay, Judge, this is not the data. The bill summary review is actually prepared for her based on data that they have not included. And I want to show you that. So she includes the data, and there is a column that says billed. Judge, the column that says billed is what the provider has billed, the provider that treated my client. What is allowed is what they decided the reasonable amount should be. And do you see this 40 over here? If you go and reconcile this, and I've deposed her on this, she explained this to me in a different case pending in Kaufman County. Opposing counsel actually in that case is not objecting. ExamWorks is objecting because they have their own lawyers and they don't want this data to come out. Do you see this 40? It says the charges for the services exceeds an amount that would appear reasonable when compared to the charges of other providers in the same geographic area. So that begs the question, who are these other providers that you're comparing to in the same geographic area? And Ms. Janice Schieber comes out and explained this. And again, I've deposed her. She went into detail of how they do it. So Judge, they have a subscription to this software called, when I say they, I mean ExamWorks, not her individually, has a software called Context for Healthcare Database. What they do is they put the zip code for where my client's provider was for that given service. Do you see this zip code here they're mentioning? And they also apply the CPT code that is shown on that particular item. And this software magically gives them some data. And she claims that this data is based on reasonable charge. She actually says it over here. It says the data that was assessed in connection with the review only billed charges in the area, not amounts actually accepted as reimbursement. The reason she says that, these folks are very careful of how they state it because the law is based on reasonable charge, not the reimbursement. So they actually make that allegation. How do I know? I don't know because they haven't provided the data. And other providers, who are they? I don't know. You won't know. No one will know because my opposing counsel says, oh, that's privilege. And that's actually not true. In order for me to file a motion with you, Judge, and say that this counterverted affidavit is not reliable, I have the burden to show you, Judge, that it's not reliable. On its face, it says that they relied on this information, that it's a database that everyone uses, and they did an analysis. And on its face, if I just file this with you, you probably don't have any basis to grant my motion to strike. Someone before me tried to do that a few years ago, and some judge did grant their motion, went to the Court of Appeals, got overturned. In fact, for Janice Schieber. Why? Because that person said, well, Jenna Schieber is not a doctor, not allowed to do this. So therefore she's not qualified and her testimony therefore is not reliable. And the Court of Appeal says, no, the statute doesn't say you got to be a doctor or this and that. The statute says you got to be knowledgeable. You got to have the experience, you got to be qualified. Once you're qualified, you can make an opinion, just also has to be reliable. My discovery is specifically trying to figure out if the statements she's making here, and let me just scroll down here. She says, I'm trying to see if these statements are reliable. Who did she use? She says that there are other providers in Canton, Texas that are charged less. Okay? I want to know who these other providers are. Let me give you a case in point, Judge. I have a case pending in Dallas County, and they hired an expert who relied on also privileged information. Comes out that they're comparing
Counsel, is that someone's phone that keeps going off, or what is that?
Your Honor, this is
Notification.
we have a this is my file. I apologize. We have a messaging system within the office because we can't meet all in the same room, and they just are pinging me over other issues.
Is there any way? Okay, thank you. Go ahead.
I apologize. And counsel, I apologize if that was bothering you as well. The case that I have in Dallas County, I was able to figure out who it is that they're comparing the provider that treated my client with. It was a gentleman that had no real practice. His resume said private practice. He didn't advertise anywhere, had no overhead, had no employees, had no software, had no malpractice, and worked out of his house. Okay. And he picked up guys from the gym, Judge, kid me not, and treated them. That's literally what he says. I go to the gym, and if someone needs services, I offer it to them. But my services are cheaper. Of course your services are cheaper because you work out of your house. You don't even have a license to practice in your house. But in order for me to make that argument to you, Judge, I need to know who those providers are. It's very possible that there are perfectly fine providers within this zip code that are providing services. At that point, I will not be filing a motion to say that this is unreliable. I have exercised my due diligence and I won't be subject to malpractice. But at this point, I can't make that argument, nor can I foresee what my opposing counsel is going to pull out in trial and try to impeach the providers as to the reasonableness of the charges. That is why this is subject to discovery. That is why in the Mendes case, which my opposing counsel cited, kind of try to twist the opinion. It said that with respect to the matters that are in the affidavit, all privilege is waived. As to the mental impressions and the opinion, it only makes sense. If they say that we analyze this data and this is our opinion, you kind of need the data. The privilege is waived if there was any. Now, what I will show you, judges, what I've asked for is actually not privileged. Even if this person was not a person who interfered into the lawsuit, which is what the case says, once they insert themselves, privilege is waived as to the content of their affidavit. Okay? Even if they were a privilege only, a consulting only expert, factual information, Judge, is not privileged. Case in point, I have a case in Johnson County. My opposing counsel hired a surveyor to help their consulting only experts who shot elevations of the slab. They wanted to show that the slab, the tilt was too much, deflation was too much. That survey reflects facts because the elevations are not opinions. They're not mental impressions. That is what the elevation was on the day that they took it. Whatever these other providers are charging, those are facts. If provider X is charging $20 to put coal tax, that is not a mental impression. That is not somebody's opinion. That's a fact. And so if they got provider X, Y, and Z, whatever those providers charged that they used in their opinion, those are facts. They're not mental impressions. They're not subject to the privilege to start with. But if they used it in their opinion, Even if there was privilege, that's waived because that's the foundation of their opinion. I tried to do my due diligence, Judge, so that I can either come before you and say this is not reliable, so I don't become the case law that's called In re Brown, which they've cited to. And you know what? I agree with them based on what that litigant did. I'm trying to do my due diligence. They're trying to prevent the truth from coming out. The reason I went to ExamWorks is because Miss Jana Schieber doesn't even have the data. It's not hers, it's theirs. And so that's who I went to try to get it. And they're trying to prevent me by trying to make an absurd argument regarding the Texas Rules of Civil Procedures. Can you imagine, Judge, if someone was to read that rule, the rules of Texas Civil Procedure, to prevent people from discovering the foundation of other experts who interfered into the case, the factual basis of it, anybody would put anything on any affidavit and file it. And then when you go and say, well, this is false, well, it's privileged. You can't get it. That's what my opposing counsel is trying to do. Whether or not that information is accurate, I don't know, but it's subject to discussion based on the Texas Rules of Civil Procedure. 195 applies to testifying experts. In this case, they have not designated her as a testifying expert, from my knowledge. Okay, even if they had done the testifying expert, that would allow me then to depose her and ask for all that information. Judge, I want you to know, if you go into your docket, that I did try to depose her. They filed a motion to quash the information that I saw in the ducis tecum attached to that notice of deposition, saying that, well, she's not a testifying expert. So what I've done is request for production, disclosures. I tried to depose her, and now I've tried to DWP. What other thing, Judge, do I need to do for you to show you that I've tried to do my due diligence and my opposing counsel doesn't want the truth to come out? And the Texas Supreme Court said the discovery rule is to discover the truth. Privilege runs contrary to the truth. Privilege can exist to protect people's interests. This is not protecting anyone's interest. This is only trying to prejudice my client, and it's not privileged to start with. Judge, I ask you to go through each and every item. I'd like to do that with you real quick. I've somewhere we have attached a copy of our request. Judge, this is the request for productions that I sent that I wanted to send to ExamWorks. Are you able to see my screen still?
I am.
All right. The raw data, reports, charts, spreadsheets, models, and any information obtained from context for healthcare, which was utilized by Janet Schieber or any other employee of ExamWorks, because she actually didn't do the analysis herself. In her affidavit, she said she reviewed the bill summary, which tells me someone else did, who assisted her and collaborating with her, and that with regard to Smith County. So that's one of the providers they have controversy. The next one is Momentum, Join, Inspire. So those two items basically go to ask for the information they used to come up with that opinion, which they say they used, but they're not providing it. As far as number 3, Judge, if you look, I've asked for any subscription agreement, revisions, modification of filtering, and or specific requirements for data requested between ExamWorks and Context for Health Context for Healthcare. Now, Judge, that's not even his objection. If ExamWorks has an objection to that, they will state it, and they have in the other case. The issue with this is Context for Healthcare is a bought and paid for subscription that is highly customizable. A lot of these companies that are in their position, they can tell the providers how to filter the data and give me what I want. Okay? And if it starts with a faulty filtering process, then what the data that it spells out could be faltered. I happen to have some engineering background, some mathematical background. So the numbers speaks for themselves. The data speak for themselves. If they're giving these people instructions that, okay, only give me providers that have less than 4 employees, that don't have malpractice, that do this or that, and don't have other policies, that may change the reasonable charge that they charge, the charge that they have, because they don't have certain costs. And so if they're telling them what to give me and they get what they're telling them what to give me, then that may not be reliable data. You can make that decision when I give you that information. As far as any user and training manual and guidelines, when I depose Jenna Schieber, they have like preset formulas and they tell them how to do this. So if they don't tell them how to do this the right way, Judge, how do I know that they did this the right way? If they've been trained to do this the wrong way, or in a way that would prejudice my client by lowering the amount, well, that would go to the reliability of their statement. It's very possible that she's the most qualified expert out there, but using a faulty method, or is using a method that is tailored towards achieving bad results for my client. And then you can opine as to that if that information is found to be true. Perhaps they provide it and there is no issue. As far as any studies and surveys and publications, treatises, database, or anything like that that they use, Judge, again, if they're using anything to base their opinion, that's all privilege as to that is waived, Judge, because they used it to arrive at their opinions. They need to tell me what it is, and I need to go and do my research so I don't commit malpractice. That's all I'm trying to get, Judge. And it's very specific. It's not that this is no boilerplate discovery. I sat there and specifically read the affidavit and the information that's presented, and I'm trying to get it. The Mendes case, Judge, which is built on top of 3 other Supreme Court of Appeals cases, is very specific that for consulting only experts, their mental impression and their opinions are protected from discovery. It makes all the sense in the world. And it works with the public policy. As a litigant, I do not want to litigate a matter for 3 years if my client is in the wrong. And if there's an expert out there who can review everything and tell my client whether they should settle, whether they should fight this, or how they should channel the litigation, that's part of doing the due diligence. That's why that is privileged. Okay? Once they insert themselves into the lawsuit, then that privilege is waived as to what they have opined about. Now, there could be other opinions that Ms. Jenna Schieber has, and the Mendes case also references that. There could be other opinions that she has that is outside of it, that has nothing to do with this reasonable charges of the momentum spine and also Smith County Health Care Database. For example, there are other providers that treated my clients that she did not include in here. It's very possible that she opined as to those and says, listen, they're within reasonable range. Let's not include it. None of my business, and it's privileged, and they didn't include it. None of my discovery goes to that. I don't talk about the MRI. I don't talk about the hospital charges because she didn't controvert them. She didn't opine as to the reasonableness of those charges. I only go to do discovery as to the items that are in her affidavit. And I need to do that to do my due diligence before I can even bring a motion to you and say this is not reliable. Perhaps it is reliable. If it is, I may use it. Judge, based on the pleadings that we have before you, the motion, the response, and the oral arguments today, I ask you to deny the motion to quash. I would gladly work with the ExamWorks. I have a feeling we'll be here because ExamWorks will object. They usually do, to try to not provide the information. At that point, we can also discuss and see what they consider privilege for some other reason. I ask that you deny the motion so that we can proceed with obtaining the information that forms the very basis of Jana Schieber's opinions in this matter.
Thank you, Mr. Hashimi. Mr. Cook, would you like to respond?
Yes, Judge. Counsel, can you please take down your exhibit there, please? Thank you. Judge, what we're here for today is whether or not a deposition by written questions is an appropriate method to discover the information that he seeks. And I would submit to you that it is not because of some crazy idea, but because the Texas Rules of Civil Procedure say that if you're trying to do discovery on testifying experts, that's all you get. It is beyond argument that consulting experts are generally more protected than a testifying expert. So if the Texas Rules of Civil Procedure say, hey, if you've got a testifying expert, all you can do is get an oral deposition, it would defy logic and reason for a consulting expert and the information that they were working on to be subject to a deposition by written questions. We've talked a lot about why we're here. Ultimately, a controverting affidavit is designed to give me the opportunity to cross-examine the treating providers as to the reasonableness of their bills. We have agreed generally to present Ms. Schieber for a deposition. I did request protection from the 30 items that they had requested she produce at her oral deposition, but ultimately they canceled the oral deposition. It was scheduled last summer. Ultimately, the other side canceled the oral deposition and has gone on to try to do a lot of things by depositions by written questions. And in this particular case, due to the Texas Rules of Civil Procedure, a deposition by written questions is an inappropriate method, and I would request that the court do quash this and plaintiff's counsel utilize what is allowed by the Texas Rules of Civil Procedure. Thank you.
Your Honor, may I respond briefly?
Very briefly, because I've got a temporary orders hearing at
Thank you, Your Honor.
just a moment.
Your Honor, I hope you heard that the opposing counsel is now referring to Ms. Jana Schieber as a testifying expert and try to apply the Texas Rules of Civil Procedure 195 to her, when their entire basis is that she's not a testifying expert. And when they filed their motion to quash the information that I needed, they said she's not a testifying expert, and you can only get the information that's on her deposition, on her affidavit. What would I need to depose her to say, did you say this? 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 Is that all I'm allowed? That's what they're trying to make you to read the statute. You can only depose her. Did you say this? Did you say this? The information that she opined about, she waived the privilege. She's not a testifying expert. They admit that she's not. They claim she's not. I wish she was a testifying expert, because that would allow me to then get all that information under 195. But when I did the duces tecum attached to the notice of deposition, they filed a motion for protective order. In that motion, they said she's not a testifying expert. They have not designated her as an expert, as far as I know. I could be wrong. Perhaps the opposing counsel can confirm. She is not a testifying expert, so 195 doesn't apply to her. And by the way, the employer is not a testifying expert. It doesn't apply to her. I didn't do a DWQ. The DWQ is only to the records. It's to prove up the records. Okay. The DWQ, if you look at the DWQ, is only trying to prove up the chain of custody and this and that. I did a subpoena, request for production of a non-party, a subpoena to get the documents that they have for the opinions that she has inserted into the case, which the Mendes case and 3 other cases in the Beaumont Court of Appeals, the Houston Court of Appeals, the El Paso Court of Appeals, all say the privilege is waived as to the information that's within her affidavit. What would I need to depose her about what's already said on the affidavit? If I'm not allowed to ask about any of the information that she used to base her opinion, what would be the purpose of a deposition? To see if she made the statements? She signed an affidavit that's got notarized. I know she made the statements. So they're trying to make an absurd reading of the law and the statute. And all I'm trying, and they flip-flop. One day she's a testifying expert, and if that doesn't work for them, okay, she's a consultant expert. They got to make up their mind, Judge. If they make up their mind that she's a testifying expert, then I will notice her deposition with a ducis tecum. I will fight for every item that's in the ducis tecum because I don't send out boilerplate stuff. I sit down and I actually tailor to understand what the very basis of her affidavit is, so that when I file a motion with you, if I do, then it will be a meritful motion. It's something that you can actually consider. And if you rule in my favor, I know it's not going to get turned on appeal. My budget is limited, Judge, so I don't want to waste it. And I don't want to file motions that have no merit. What I'm trying to get is to the bottom of this and get the information they say they used to define as to whether or not these fees were reasonable.
Thank you, Mr. Hashimi. Okay.
Thank you, Your Honor.
I understand the arguments, and I didn't understand Mr. Cook to say that she's a testifying expert. I understood his argument to talk about the protections given to consulting experts on the comparison to a testifying expert. So I understood that, Mr. Cook. So, all right, gentlemen, what I'll do is I'm gonna review the Mendez case in conjunction with your arguments today, and I will render a ruling before noon tomorrow. I've got temporary orders hearing right now, and then a family law matter after that. But I will commit to you that I'll have a ruling on this before noon tomorrow.
Thank you, Your Honor. Thank you, counsel.
All right. Thank you, gentlemen. You have a great day.
Thank you.